Hey everyone, welcome to the Legal Hour. It is 12 o'clock on Tuesday, and I am, as always, excited about our episode today. Before I start, if you don't know me by now, my name is Tamika Johnson. I am an estate planning attorney in Georgia. So if you have been procrastinating on either creating your estate plan or updating your estate plan, including wills or trusts or power of attorneys, what you need to do while you are in the right frame of mind and you're competent and not when you are not. Power of attorneys, healthcare directives, and just figuring out ways to avoid probate. You can go ahead and visit my website, johnsonlawpractice.com. If you are in the state of Georgia, you can schedule a consultation. There's also an ebook that you can download for free, just letting you know about the different estate planning mechanisms that we have. Today, though, I'm excited about my guest because it's someone that I've known for a very long time. We are University of Georgia UGA grads from undergrad, graduated back in late 90s, I would say. So I don't want to tell our age too much, right? So go Bulldogs, anybody out there who was from UGA. We took a little, our paths were a little bit different. So after we graduated from college, I took a little time off. I took a year or two off before I went to law school. But our guest, Miss Lajuana Ransaw, she went straight to law school, again, at the University of Georgia, and just kind of had a seamless path to practicing law. She was the good girl. She did everything right. She went to law school, passed the bar, started practicing. She was a clerk for a judge out in Clayton County, here in Georgia. And she was there for a while. And then she's now in private practice where she's been there for a good number of years now. Smith, Welch, Webb, and White, also in McDonough. So she's going to tell us a little bit about what she does. As you know, this episode is about employment law, discrimination, what your rights are as an employee, the things you're supposed to do as an employer. She's got a tremendous amount of experience in that area, in addition to other areas. She also represents several cities, housing authorities, is well versed in state and federal employment laws, ADA, which is the American Disabilities Act. She has a long list of things she does. Also commercial leases, residential leases, sales and rental agreements and litigation. So with that, Ms. Lajuana Ransaw, thank you for coming and joining us today.
Thanks, Tamika. It's a pleasure to be here with you.
Yeah, so tell us a little bit about what you do, your background, and again, I talked a little bit about what you do, but if you go into a little bit more detail as to what you do.
Okay, well, I'm a native Georgian, as you said. I went to UGA undergrad and law school, and my primary focus is employment law, which is our topic today, but also governmental entities law, and commercial real estate, other real estate, and litigation involving compliance with federal and state regulations. So a lot of what I do on my day to day, and everyone's like, "Oh, you're in the courtroom every day?" No, I do a lot of contract interactions, and I do a lot of litigations regarding the implementation of federal regulations and making sure that my governmental clients are in compliance with that, as well as my individual clients who come in and have cases with regards to discrimination. So I do a little hodgepodge of everything. I'm kind of throwing in together. So that makes it interesting. I don't like to do just one thing at one time. So it makes it interesting because I do deal with regular folk as well as governmental clients.
I'm super proud of you and excited for you. I know you work hard. This is how I know you work hard, because last week I sent you a text just telling you like, hey, I sent you the email, to get on the show and do all that. And Miss Ransaw sends me a text on Saturday morning at 6:30 in the morning, said, okay. And I was like, wait a minute. Why are you up at 6:30 in the morning? He said, I'm doing laundry. I've got to get it in. And then I thought, why am I up at 6:30 in the morning responding to her?
It's work-life balance. It's getting those things in, just making sure that home life stays together. I have to have some semblance of organization or I'll go crazy. So, but yeah, I'm an early bird, so I'm usually up by 4 or 5 o'clock in the morning. I'm
Wow.
returning emails by 6, and so that's kind of my regular routine.
You are definitely dedicated. Do you still handle cases with school districts and the process there?
I do. I actually represent school districts. So I'm a member of COSA, which is the Council of School Board Attorneys. So if there are issues related to, it could be compliance regarding Title IX, it could be employment issues that is related to the school system. It could be a myriad of complaints from OCR, but I represent the school interests and the educational institution's interests, and not an individual's claim against the district. So that's kind of where I am.
Okay. And I have to say, a few years back, my daughter was having an issue with some classmates or something in a class, and I called you. And I can't remember if I was just venting or I was asking you specifically like what to do. And you like sat me down, you were like, okay, they need to have this, they need to have this kind of hearing, they need to have this kind of notice, da 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 da. Because I didn't know anything about the area. And so then I goes back to the principal and I said, we need this, we need that. So he took me very seriously after that because I didn't know anything, but I regurgitated everything you told me.
Mhm, mhm.
You got
Yeah,
it.
yeah.
So, if you are on here and you like to ask a question or you have a situation regarding employment law as an employee or as an employer, you can do so in the comments. You can write the question in the comments, or you can join us live. The link is also in the comments, which I believe is on the YouTube channel if you're watching there. So, but we do have some questions already, and so we're just going to
Okay.
kind of go through them. Um, I've been self-employed or an entrepreneur for over 20 years now. So a lot of things I have not necessarily had to deal with, but when you do start working with other people, you do start hiring people as you're growing. You definitely have to be cognizant of your employees as an
Mhm,
employer and know what your rights are as an employee. I know
mhm.
I've gotten calls and I've referred some over, but we're going to start with some basic questions. I'm going to start the very, very basic question, which is, the difference between what are the basic differences between an employee and an independent contractor? And I know I have a lot of entrepreneurs again that who follow me, so that's a
Mhm.
good one to start off
It
with. The
is.
basic difference between an employee and an independent contractor. What says you?
Okay, so this is an area that I get asked about a tremendous amount of time, especially with small companies, small businesses who are growing exponentially, who are trying to bring on extra help. Their main goal is to try to effectively bring on the help, but not open themselves up to the headache of having to do withholdings and things of that nature. The IRS has put together a checklist that is literally point and click, with regard to the criteria that makes a person either an independent contractor or a employee. The first thing that you have to look at is with regards to the control of the work. If you are a true independent contractor, then you control what time, what date, uh, your level of expertise and skill set that you bring to the job. You provide that service to the party that you're providing that with. Normally, there is a contract or agreement between the parties, as well as there is a straight 1099 salary. There are no withholdings or deductions. However, if you're an employee, that's when you get into a situation where the employer kind of controls the work, they provide the equipment, they tell the worker what time to be at a specific location, what time to perform the job, um, and things of that nature. The biggest consequence or the biggest difference is the withholding requirement. If you have an employee, and I've had several employers come to me and say, "Hey, Luana, we 1099 someone." And then we go through the checklist, and I'm like, well, did you tell them where to be? Are they on call? Can they tell you that they don't want to perform a certain task, duty, or obligation? No, well, they don't meet those criteria to be an independent contractor. The biggest thing is when you're dealing with that is your employees, you do have to pay quarterly in their wage earns based on their wages and earnings, a tax that you withhold from them um, from each paycheck. When you 1099 them, you just give them all of their money, and then they will have to pay all tax consequences. But for the employees, you do have to pay in, and that's either quarterly or biannually for state and local, federal and state tax.
Yeah. So I had to say, I found out last year when we had a nanny that our nanny was an employee. We had
Yes.
to, pay the quarterly taxes and all of
Hmm.
that, which I never even thought of beforehand. We were considered an employee
Hmm.
for a nanny, which was very, very interesting to me.
Hmm.
Okay. So that is good to, so a few years ago, I remember hearing it was like a controversy with exotic dancers
Hmm.
and whether or not they were independent contractors or employees. And I don't know what the result was like legally. I just remember there was like a lawsuit about it. But can you give us a little
Hmm.
bit more information about that, where they stand as exotic dancers?
So I do remember vaguely that case. And the argument with regards to that was the club owner mandated what time they came to work. They mandated how long they stayed on shift. They mandated those things, and those things take you out of the realm of an independent contractor. Normally, if you're independent, if you're truly an independent contractor, you engage the time, method, and means by which you provide the service to the party that you're providing the service to. If you think of it like a plumber, your plumber makes the appointment with you and gives you a window of when they can come, and they come in, they do their professional services based on their expertise in their skilled area, and they are truly an independent contractor or a vendor for you. um, with that same regard, if a exotic dancer is truly an independent contractor, then he or she can make whatever hours, they will bring whatever expertise, and they will not be under the control of the employer to work certain shifts. In this case, and I think it's the one that you're referring to, they were required to work a set amount of hours. They were required to come in dressed in appropriate attire, and they were required to give a portion of their earnings to the upkeep of the club. So you had to pay amounts for, like, for example, the DJ, or you had to share in the cost of whatever maintenance and other things like that. So their gripe was, or their objection to that was, if we're truly independent contractors, um, we should be able to control the time and manner in which we provide our services, and not be required to come in on a shift basis. And so that was the objection. I don't know what the outcome of that was, but one thing that I do know is that if you mischaracterize your employees as independent contractors, and you fail to submit the quarterly payments, you owe taxes and penalties on those quarterly payments from the date that they should have been paid. So that is a very, very, very key thing that you need to determine very early on in your employment relationship with whoever you're bringing into your business.
Yeah, that's good information. Okay, so we have another question. Do all businesses have to have a written process for employee complaints, even if there's only a couple of employees?
Okay. That's a very good question. Okay, so what the law requires, there is no requirement for private companies with regards to policies and procedures. However, there is a requirement that all businesses comply with federal regulations that govern non-discrimination policies, and things of that nature. The reason why you would want to have those policies in place would be to show that you're not being deliberately indifferent, that you don't condone certain behaviors and actions of your employees, and to give guidance to your employees. If you have ever been through a investigation, either through OSHA or any federal regulatory body, which I've done a lot of them, the first thing they're going to ask you is, what is your policy and procedures with regards to whatever complaint that is brought to them. So it is a good idea where it's not required. It is a good idea to have those policies and procedures in place. Some things are required though, in industry specific. For example, if you're in logistics or trucking, there are certain policies and procedures with regards to drug screening, safety checks, and things of that nature that have to be performed prior to an employee being brought onto your company. But with regards to a employee manual or a group of policies and procedures, there is not a legal requirement, but it is strongly recommended by me to have those in place before you bring in employees.
Yeah, because I would assume that coming up with a manual after you've been sued or complaints been filed against you is probably too late.
It is. It's too late. I mean, it's too late. And the thing about it is, a lot of times they'll look at it as, okay, well, this was a problem. You probably knew it was a problem, and you're just trying to cover the actions that you did. So it's just best to have those policies in place prior to.
Okay. And do you suggest or advise that small business owners that they actually go to an attorney to draft their policies and procedures?
I do. I do because there are nuances that a lot of small businesses don't um, know about. They just look at what's happening in the industry, and what could be happening in the industry is totally wrong. But the law is always changing with regards to that. There are always different regulations that you have to follow. There are recent Supreme Court cases that came down that govern discriminatory treatment with regards to equal access and implementation of policy for employers. And so, with that, it's always a good thing to go and consult with an attorney when you're dealing with those hiring things. Like, for example, I had a client come to me with a complaint that was filed against them regarding an applicant. And so they were kind of taken aback because they thought, okay, well, this person is not even a employee of my company. They just applied and were denied. And I said, well, there are certain protections, even as an applicant, with regards to discriminatory treatment that apply. And so, in knowing what applies at what stage of the engagement of that employee or applicant is a good thing to have. And so, consulting with an attorney, even if you don't get with an attorney to do your whole manual, but just getting with them to know key policies and procedures that you need to kind of address. And our firm does it. A lot of firms do it. We work with small businesses as far as formation, making sure they're formed correctly, that there are those corporate protections there. But when it comes to the day-to-day implementation of those policies and procedures, you really do need to have that legal guidance to make sure you have all the key ones in place.
Yeah, that's good information as well, especially for the small business owners, because when you're starting a business, you're trying to like cut all costs,
Right, right.
and but sometimes it comes and bites you in the butt. Because I would have never thought just even like an applicant
Mhm.
would file a complaint or try to sue you over something. So
That's
that's
correct.
very very interesting. Okay, so next question is a scenario.
Okay.
I only laugh because I feel like some of us would go to jail after this happens. But we don't want that to happen. It's okay. So the question is, I was physically hit by another coworker. I reported it to HR, but the employee is still there. Can I sue the company and or coworker for damages?
Okay. So this has to do with, does your company have a zero violence workplace policy? We always go in when we do our assessment of our companies that come to us with regards to employee violence and things of that nature. Our recommendation is that the company adopt a zero tolerance when it comes to violence in the workplace. That allows the company to access the um, protection or the defense that this was a non-foreseeable criminal act of a third party, whether or not that party was um, was known. Now, if they've been going back and forth, and there have been some difficulties, then it's best to nip that in the bud. But if truly this is a random criminal act or random violent act, the company will be shielded from liability from based on that, so long as they did not have knowledge that this party or the person that engaged in the violent activity had the propensity for violence. So that will be the first thing. Whether or not they have a action against the individual employee, yes, you can always take if you are harmed or assaulted at work, you can always sue for those damages caused by the injury, and you can do that personally against the person that caused the injury. But with regards to whether or not your employer can be held liable for those damages, again, it goes back to whether or not this injury was foreseeable and whether or not there were actions taken such that they would protect you against these matters. And what the courts have deemed is that as long as there's a policy in place or there is no foreseeable cause that the employer would be on notice this person would be harmful, then the employer might need to will not be held liable. Now, is it a good idea to bring that person back to work the same day or the same week? Probably not. I would not. If they engaged in violent behavior, then that should be a ticket to not allowing them back, because at that point, the employer is on notice that this person has engaged in violent behavior. And so any subsequent act by this person that's harmful to other employees would be foreseeable. So it will probably be a bad idea to bring them back to work.
Yeah, probably. Okay, so does that have to specifically again be in their policy and procedures written somewhere that there's a zero violence policy at the workplace, or
I
we have a
recommend
policy and
Yeah.
it doesn't address that. So would the employer be liable if they don't have that specific language in the policy?
They would not automatically be liable, so long as they can show that there was no prior altercation with this person or there was no prior indication this person engaged in violent behavior or things of that nature. Generally, when I get employers coming to me or employees coming to me with situations like this, there's been a history of ongoing animus between the two, or some type of issues with this other employee, harassing behavior that escalates up to violence, or things that have led to this in the past that have kind of been brushed under the rug by the employer. It is never a good opportunity to think that things will just fizzle themselves out. You do have to take a proactive step if an employee comes to you with a concern, especially with regards to safety.
Yeah. Wow. Yeah, I would hate for anyone to have to go in a work environment like that,
Yeah.
especially because yeah, things don't just happen. They just kind of like build up, and
Right.
I would assume the best course of action is to, whenever something does happen, is to report it to HR, just so you'll have documentation in the event something does happen. Okay. So I have another question here. I have a secretary who just isn't that good and honestly has a bad attitude. Do I have to give her a chance to get better, or can I just say it's not working out and fire
Okay. Well, let me just explain to you kind of how Georgia, of course, is a at will to work state. And I'm assuming that your secretary doesn't have an employment contract. If she doesn't, and she's not meeting proficiency as far as her ability to perform the work efficiently or in accordance to what your requirements are for your job, you always have the right as an employer to terminate her. Now, the question may come up. Now, when I say that with some caveats, and it's always caveats, right? When you're attorneys, you always have, but there might be some things that come up, right? So the things that you might want to consider is that if you do terminate this employee, they may bring claims of discrimination based on age, race, sex, things of that nature. So making sure that you have proper documentation of insufficiencies, things where you have redirected them, Have you provided direction to them and they're just not cutting it? That will be helpful to show that you have at least tried to engage them in bettering their work performance. Is it required? No. But if you are challenged after the fact with a wrongful termination based on discrimination lawsuit or claim with the EEOC, one of the things they're going to ask you is, do you have documentation with regards to your telling this employee that their work performance was not up to par or was not sufficient? And so having that documentation is invaluable to show that this is a non-discriminatory reason why you terminate this employee, and you have the documentation to kind of back it up.
Okay. So it sounds like it would be in the best interest to, I guess, have a review and then just kind of communicate with the employee what's going on. So from like a realistic standpoint, it's kind of like, yeah, probably I should, talk to them first, but legally you don't have to.
That's correct.
Okay. All right. So let's see. So I think you kind of went over it when we asked the first question about independent contractors and employees, but I've been working with an independent contractor for 3 years, but want to hire someone else for the job. Do I have to give the contractor notice or can I just stop using him?
Okay, so it depends on your contractor agreement. A lot of times when you have an independent contractor, it is usually a job specific engagement, meaning that they're to perform a specific task. Usually that is by contract that you have an agreement for them to perform that task. So as long as you are abiding by your agreement, if you have one, then that's fine. But but as far as notice, if you don't have an agreement with them, which I suggest if you have an independent contractor, you do have some type of agreement showing that they are an independent contractor. But as long as you can, but you can terminate. Terminate those services.
Okay. You said you can or can't terminate the services? You can. Yeah. Okay. So I know that's just one day. It's like, I don't need you, and that's it. There's no recourse. Basically, right. As an independent contractor, it's good because you have flexibility, right? But
you do have the flexibility,
and it's bad because one day you may come in and not be there anymore.
Right. But the beauty of it is when you have those independent contractor arrangements, and normally it does give you the flexibility to utilize the skills set of a person or a company for a specific task of engagement. And so if your needs may change or and things of that nature, and it's okay to change your hiring structure or to move on. It might be more cost effective. Let me just back up. I've had a lot of companies when they first start up, they try to get contractors to come in and have a lot of expertise and experience, right? So they don't have to have a lot of oversight because you're so bogged down in the day-to-day operations of trying to get your business off the ground, managing efficiently. And so you need someone to come in already knowing the job, already knowing the industry. They can pick up the ball and start running. As you grow and as you get more experience in your job or with your business or industry, you may find it cost efficient to bring in employees under you who don't have necessarily the expertise of an independent contractor, but that can work and do the job as you train them, and they can perform the same task for the reduced cost. And so that's the major part that I've seen with regards to shifting from an independent contractor to regular employees. And so in that regard, as long as if there is an employment agreement, as long as you can comply with that, you're fine.
Gotcha. Okay, our next question is very interesting, and I say it because in recent years, it's been a thing as far as hairstyles, whether it's in the school or in the workplace, and especially for African American men and women, and like braids and natural looks and that kind of thing. And so, and I don't know where Georgia stands, so you can let me know a little bit about or let us know where it stands on that. But I have seen certain other states just provide protections that it's okay to wear these more ethnic hairstyles to work and not be discriminated against or fired because of it. So this question is, can I fire someone for having a hairstyle that, in my opinion, is too out there for me and my company brand? Not the same question, but kind of like along the same lines. So tell us your thoughts.
Okay, so it's so funny that this comes up. I just advised a client on this. It was a governmental client that I actually advised on a question with regards to hair styles and things of that nature. So the rule of thumb when it comes to this, with regards to whether or not a style is targeted for being appropriate in the workplace. There's a different standard when you're talking about a private employer and a governmental employer. I normally deal with governmental employers, and so our concern with most of the issues that I deal with is, does this hairstyle or does this um, dress or whatever confine with safety? For example, I had a fire chief come to me and say, "Well, Luana, there's certain gear that we have to wear that you cannot have your hair a certain amount of feet from your hair. So braids and things of that nature, they have to wear a cap over it, or the safety gear will not fit appropriately over it, such that there could be some dangerous vapors that gets under the mask that you wear." In that case, yes, you can limit the hairstyle or hair dress such that it complies with safety regulations that are required by federal regulations, OSHA, things of that nature, especially with your fire departments, your police, things of that nature. When it comes to a private employer, again, Georgia's an at-will state. But when you get into making differentiations based on hair or nails or selections of um, things of that nature, you're on a line, right? I can't say it's right or wrong, but you do run the risk of a claim of discrimination. And basically, they would say that it was discrimination based on ethnicity or racial discrimination. And my rule of thumb has always been, there is no bright line rule of what is professional dress, right? But there are professional expectations when it comes to employee conduct. For example, as an attorney going into a courtroom, I've never seen an attorney walk in there with Bermuda shorts and a tank top, right? It's always expected that you're going to have on a suit, a jacket, and things of that nature. Just as that expectation is there for that, you can say that you don't want or that you're limiting professional dress such that it's neat, well kept, and clean and presentable. Um, if there are hairstyles that, and I can't think of anything um, that would offend, I think that the one of the limitations, that I had a real old policy manual that I redid for a school district. And one of the requirements was that men couldn't have facial hair. Well, back in the 60s and 70s, that was kind of frowned upon. But now those things have changed. And as long as it doesn't present a safety issue or things of that nature, then why are we having the prohibition? So when you ask those questions, there's a different generational shift and things of that nature that you can kind of see. But with regards to prohibiting a hairstyle, I would say tread lightly and make sure that you are not infringing upon a person's expression. For example, one other thing is, for example, make sure you're not doing gender-based requirements. For example, males can't have long hair. The Supreme Court has issued a case that says you can't put those gender expression requirements on employees because that's discriminatory. So just making sure that whatever you implement for one gender, you do for the other, but you can have professional requirements. I think I lost
Okay, so I'm not sure what just happened. I was not anything. So I apologize for
That's
that.
okay.
Thank you for staying. Um, I did want to follow up, and I know you were speaking when I abruptly got cut off from my internet. Um, I did have a quick hypothetical, and that was, let's say an employer relatively conservative and they hire someone and they just have like regular hair color, but then a year or two down the line they start coming in with like red and pink and turquoise hair, and they're just kind of like, this does not really fit into my brand or what we represent. Is that a
Mhm.
basis for firing someone? Is that okay? Are you protected? Is that okay being in that will state?
Okay, no, you're not. Different colors, bright neon colors. An employer can say that a person's hair color needs to be closely assimilated to natural hair colors with regards to that. But an employer can't say, well, all men need to have short shaven hair, and you can't have long hair, or you can't have this. And they, I want to go back that Georgia is again an at will state. So if you can fire an employee for any reason or no reason at all, but just make sure that it's not a discriminatory reason.
Okay, so clearly something's going on with my internet.
Okay.
So we're gonna try my phone from here on out.
Okay.
Okay, so I'm sorry.
It's
Um,
okay.
with the hair color again.
Okay. What I was saying was the hair color. Yes, you can limit and say that you want all employees to have hair color that is assimilated to regular or natural shades. No neon, no pink, no greens, and things of that nature. That would not be protected. But what would be protected is if there is an ethnic expression such as braids and things of that nature that does not interfere with the safety and of the job performance, then that would be kind of questionable. You're on mute.
Okay, but I did hear you,
Okay.
and I need to disconnect from. I'm so over this. Okay. Well, I'm trying to make it quick before I get cut off again. Having me look crazy.
The internet is great when it works, but when it
Oh my
doesn't,
goodness, I don't
it
know what's
does what it
going
wants
on.
to do.
Okay, so I do want to get to this question though.
Okay.
The question is that I believe I'm being passed up for promotions at my job because I'm Black. Can I
Hmm.
sue my employer for discrimination? I would like assume that you need to have like some really good documentation and evidence that this is happening. Um, because you don't know, like you don't know who's more qualified or whatever it is. Um, just tell us a little bit about that if you just believe you're being discriminated against. Or not
Right.
promoted.
So,
Oh, great.
right. So, if you have a belief that you're being discriminated against, the first step is to talk to your HR rep. Most employers have a internal grievance procedure with regards to racial discrimination and things of that nature. Um, as well as if that is the case, then you have the right to engage in that report of your suspicion of racial discrimination without retaliation. They should perform an investigation as to whether or not there was discriminatory treatment with regards to the promotion processes in the company in which you work. If you get a finding letter, usually you'll get a determination letter that lays out that there was an investigation, things of that nature. If you're not satisfied with that, the first step in taking legal action would be going to the EEOC, and that's the Equal Employment Opportunity Commission. You file a charge of discrimination that basically lays out your allegations of what you believe is discriminatory behavior that happened on your job. And I will tell you that on that charge form, because I filled out many of them on behalf of some clients, they're going to ask you if there was discriminatory practices. Was there anyone who was who was similarly situated to you, meaning they were in the same position that you were in, and they were treated either better or worse than you, or is there someone who can be a witness as to the treatment that occurred? So the onus would be on the complainant or the person who's filing the discriminatory charge to have those persons who they can cite to say they had less experience than me, but they were promoted due to they were a different race, or they were younger than myself, or things of that nature. But you do have to show why you feel you can make those allegations, but you do have to show proof or have proof and evidence that there was actual disparate treatment.
Mm. And let me ask this as far as the HR, because again, there's a lot of small businesses out there. Does a business have to have an HR department, or would it just be to the owner? Is there a requirement? I guess I'm asking as far as having an HR department.
Right. So there's no requirement that you have an HR department, but your owner would take the place of your HR rep.
Okay. And is this the same for, since the EEOC, that's a federal regulation or law? Does it matter whether you're a private business or a governmental agency?
It doesn't matter. You can go to there are two levels for the EEOC review. There's a state EEOC agency, and there's a federal EEOC agency, and you can apply to either one or file a charge of discrimination with either one. I will tell you that due to the pandemic, the state agency is very backlogged, and so what we've been seeing is that if they do find that there is a need for investigation, they will go ahead and forward that over to the federal EEOC.
Let me just ask this though. Do you find in the cases that you had, like percentage wise, if someone makes a claim of discrimination based on race, do you find that it's warranted, or it's been found there has been discrimination, or usually no?
So race is one of the hardest things to prove when it comes to discriminatory conduct and cases with discrimination. Your more easier cases to prove would be medical or discrimination based on a medical condition. Then comes age, then comes race. As you know, when you are looking at protections from discrimination, it's easier to prove that a employer engaged in that either because they violated FMLA or they violated protections against employees who were terminated due to their advanced age over 45. There are certain presumptions that the termination that is not based on a neutral reason or a good reason could be based on their age. And so those are easier cases to prove, right? But when you come to discriminatory treatment, you really do have to show that there was adverse actions taken based on the ethnicity of the person, of the worker. The only time that I've really seen that happen, or the only time, the stronger cases, I would say, not the only time, but the stronger cases are those cases that involve disparaging comments, racially based gestures. I had one where there was a very offensive cartoon that was placed on my client's computer that was very distasteful, and things of that nature. When there is an objective um, concrete evidence to show that this is the intent of the party that's engaged in this behavior. So when we see those type of cases, we really have to show not only there's a pattern of disparate treatment, but there's also some external factor that shows that the intent of this either employer was to discriminate based on their race.
Hey, Luana.
Hey.
Wow. So I'm going to kind of wrap it up because I don't want this to happen again. So
Okay.
I'm just going to end with one more question. We actually had several more questions, but I don't want this to keep on happening. So last question is going to be, does my employer have to pay me time and a half if I work more than 40 hours? Apparently that's a thing, that people they're not getting paid, which I can't imagine because I was a stickler for my time. And I was like 40 when I worked for someone, which again has been well over 20 years. But
Right.
I'm like, we 40.5 and I'm looking for time and a half on that 0.5. But do employers actually not pay, or do they have to pay? Sometimes I know it depends on, if you're salaried, hourly, that kind of thing. But can you just talk about that?
Yeah, so under the Fair Labor Standards Act, and that's the federal rule that kind of governs how we pay our employees. There are stipulations that says that if you are an hourly employee, generally if you are punching a time clock, you're doing manual or labor, things of that nature, any time over 40 hours has to be paid with time and a half. And those are regulations for blue collar workers, those manual employees. If you are a salaried employee, however, those rules don't apply. However, the FLSA or the federal government has implemented that if there are overages for those employees that fall within a certain criteria, then they can be given comp time. A lot of my governmental employees don't necessarily give time and a half for salaried employees that meet the definition for overtime compensation. But what they do is they give them additional compensatory time, which is time off that can be either paid or unpaid at an hour of accrual for the time that they work over. So that's what I'm normally seeing. The trend is for those salaried employees that make below the threshold amount under the FLSA that are entitled to additional compensation for the hours that they work over. And when I say compensation, like I said, that could be comp time, and that's paid time off or unpaid time off. Either way, but you would compensate them for the additional time over with the comp time. As an employer, I strongly suggest that if you have a system where you are having employees do overtime or wage, or you do wage hour, anything like that, I do some wage hour cases. The first thing the FLSA, the first thing that the labor commissioner is going to ask you for, if you have a time clock system, is I need your time clock system data. Okay. So if you have a situation where you have hourly employees, there has to be a meticulous system that keeps up with the time that they work. If you have employees that are salaried, again, they're going to ask you for those wages for that information with regards to were they paid for the amount of time that they worked. That is the key question that they're going to look at. Why is that important? Because if there is an FLSA claim or wage hour claim, is what we call it in the industry, and you don't pay an employee what they are owed for the time that they work for you, then you have to pay them not only the wages that you owe them, but you also have to pay what's called treble, or three times the damages that you owe them, plus their attorney's fees in collecting that amount from you. So it's a very, very, very important thing that you keep up with the amount of time that your employees work, and that they can't come back with a claim that they were not paid for all time that they work for you as an employer. But to answer your question, are you entitled to paid time or just a time and a half? It depends on the type of employee you are. If you're an hourly employee, most of your blue collar workers, most of your manual laborers, most of your employees that have shift work, yes, you would get that time and a half, or anything over 40 hours. But if you're on a salary, your employer may use the compensatory time remuneration that's been approved for under the Wage and Hour Fair Labor Standards Act.
Okay, so you're saying the employer may use the compensation portion of it. Do they have to? Because I could imagine, I'm just thinking that, people, because what's instilled in my head, right,
Mhm.
before speaking with you, if I'm salaried, I'm just kind of expected just to work overtime sometimes and expect not to get paid for it. So should I, as an employer, be keeping track of those hours? Um, I just would assume the employer's not like, oh, hey, because they may not know that you worked overtime, really.
Right,
I mean, really, because you're not clocking in. So,
right.
how does that work?
So for my governmental employees that are on salary, they still have a sign-in system where anytime you are working on behalf of the authority or on behalf of the governmental entity, your time is accounted for. Whether that be a formal sign-in clock, which some of my government employees, even though they're salaried, they do still maintain when they come into the office and things of that nature. Whether it be manual sign-in, whether it be punch-in, or however they do it. Some of my governmental employees have a system that's on their laptops or on their cell phones, and they can remotely say, okay, I'm starting my work day, I'm starting these things like that. That's a way that you can keep up with time and time management system for your employees, even if they're salaried. It's just a good thing to have if you're going to engage in compensatory time remuneration. And so, when do you have to do that? There's a test. There's a bright line test, and I think the threshold amount is, I think, under 60,000. And so, for those administrative staff members that make below the threshold amount, compensatory time as remuneration for in excess time worked over 40 hours is something that the law requires now. And so what we do as a system for most of my governmental entities, before you engage in overtime hours, it has to be approved by your supervisor or the owner of the company if you have a small company like that. That could be a very good system to make sure that you don't get caught in a trap if they do go back and say that I wasn't compensated for all time work.
Yeah. This has been very, very informative. A lot of things that I just didn't even know about. So I'm definitely
Mhm.
glad that we had this conversation. Very helpful again for small businesses and small business owners specifically. And there's a lot more, I guess like rights that I think that employees may have, but they don't assert them
That's right.
because, of backlash, perhaps, not wanting to seem a certain way, even
Mhm.
though, legally they're entitled to some things.
Right.
So, it's a balancing system. Do I want to keep my job and keep my peace, or do I just kind of suck it up? But
Right.
that's something that, people have to determine on their own. So before I get cut off here again anymore, I thank you for your patience. I do, it's being a professional and just staying around.
It's fine.
If
It's fine.
you want to would like to get in contact with Attorney Ransaw, her website is at the bottom. She is again at Smith Welch Webb and White. The website is smithwelchlaw.com. here in Georgia in Henry County. So again, thank you for coming on. If you have any questions, if you're catching this on the replay, you have any questions, you can put it in the comments. I will see them and I will pass them or will forward them on if it's something that Attorney Ransaw can do. Other than that, thank you. So last week I misspoke and I was saying this week was going to be the week that we do child support and child custody, which you are very well familiar with from your former career. So I want to suck you into that one, but next week, I remember hearing all the cases, all of the drama, and it was like
all the drama. Yeah, that's a different beast. I did child support and child custody for 12 years when I worked with Judge Collier over in Superior Court, and that is a different beast and animal of itself. But it's an area that has changed, and it's really needed. But I just, I found my niche in governmental entity law and employment, and I don't want to turn back. So
different type of drama, but yes, I get it. So yeah, that'll be next week. Next week will be our last episode for this season of Legal Hour, where we're going to end it with child support and child custody, with an attorney who was out in your area as well. So join us for that. If you need some assistance in that area, you know someone who needs some assistance in that area, definitely tune in. Thanks again, and we will see you all next week. Have a good day.
Okay. All right. Bye-bye.